Hello, WiCCD members. My name is Maya Shukeri, and I am WiCCD's Education Committee Director. I'm happy to introduce our series, Finding Your Niche. In this series, we will interview female criminal defense lawyers who practice in a specific area within criminal law. The goal of our series is to highlight the work and accomplishments of female criminal defense lawyers, but it is also a way for us to introduce you to specialty areas within criminal law. We hope we can help you find your niche. Enjoy the series.
Hi, Laura. How are you?
Hi, Maya. I'm doing well. Thank you.
Well, it's very nice to see you. And I'm happy to have this discussion here today with you because we're going to be talking about a subject that actually is very important to a lot of our members, especially our female and female identifying members, because you said that you wanted to talk about well, we were talking about several things that you were interested actually in talking about, but we agreed that this subject is actually very important for many of our members to talk about right now. And that is how to find confidence as a female criminal defense lawyer in this profession that still is very male dominated. So we're going to talk about that because it is sometimes difficult, especially for female lawyers when they're starting off. I mean, eventually when they become confident and they've established themselves, becomes easier, although not always. They still have to struggle, even at that level, sometimes with criticism. But especially at the beginning, it might be more difficult. So I'm honestly very excited and happy to talk about that. And I'm glad that you're here to chat a bit. And you're going to be sharing some of your own experiences and how some of the things that you've seen in your practice. But before we get into that, I would like you first just to introduce yourself. I know a lot of people know you, but just for those who don't, if you can introduce yourself and then we can get into the subject.
Sure. So my name is Laura Metcalfe. I'm a criminal defense lawyer at Addario Law Group. I was called to the bar in 2017. I started, I guess, my criminal law journey in Ottawa, actually.
Mm-hmm.
I did my undergrad at criminology, was fortunate enough to get into a criminal defense firm in Ottawa through a field placement with Bruce Angle. And so I spent many years, including law school, working with the criminal bar there. Just as an aside, the Ottawa bar is just filled with a number of wonderful people who would mentor me informally along the way. And then eventually I landed myself an articling job with Alan Gold, where I stayed with him for about 5 years, and then moved to where I am right now, probably about 2.5 years ago.
Mm-hmm.
And I practice criminal defense law predominantly, but I also deal with some administrative law. I deal with police cases sometimes. I deal with law society cases, some college matters, really the
Regulatory.
the areas of the law that circle around
quasi-criminal. Yeah.
Yes. Where the stakes are obviously high for them, but jail is off the table.
Yeah. Which makes it less stressful a bit than criminal. But you do a lot of criminal law, and you.
Yeah,
and
my practice is predominantly criminal.
And I'll have to mention both trial level and appellate level.
Correct.
Yes. Okay, so Laura, and that's why it's really good to have this chat with you about this subject, because you did work with some, I mean, you did and you still are working with some very like prominent male criminal defense lawyers. I mean, everybody knows in the criminal law world in Canada, and especially in Ontario, who Alan Gold and who Frank Addario are. They're very respected lawyers in Ontario. But I mean, we'll have to say that, you know, like obviously working in these firms is very demanding. They're top lawyers, they run a lot of work, and it has to be done very well. And so maybe if we can talk in general about how it is, like some things that you know, whether it's from your own experience or in general, about how can you then establish yourself and make a name for you, because it's very difficult to make your own name when you're working for Alan Gold or working for Frank Addario. But you are building your own name. Like people know who Laura Metcalfe is. You're not just working in Frank Adario's firm, you're Laura Metcalfe. So how do we do that? How can a female lawyer do that?
So I think my answer would be two parts. Obviously, one is on you to the extent that, you know, you work hard. In my first couple of years of practice, probably not for everyone, but I almost exclusively worked. I really did everything I could to learn as much as I could about the criminal law and as much as I could from Alan. And I tried to take advantage of every opportunity that I could. But then the second part of that is I was very fortunate and continue to be fortunate that the male seniors in my professional life have always really went out of their way to allow me to not only get the experiences, but to be seen. And so whether that was, for example, Michael Lacey and Alan were in the Oland criminal murder trial in New Brunswick, and they were at the same time supposed to be working on a 11B book. And they had said, hey, just take a stab at an index, see what you can do. So I, as they were busy with that practice, started then taking stabs at drafts of chapters and working on writing a large part, and then sending them the drafts to edit and feedback. And so I not only learned from that, at the end, they had both reached out to me to say, we've decided like you must be a co-author, right? That was never anything that I'd asked for. It was not an expectation. But it was, for me, like I was quite grateful for the fact that they absolutely had no obligation to do that. And what we can often see in the flip side is the juniors often write the articles and then, you know, sometimes see
and
like
no recognition, their
you
names
can maybe see a footnote that thanks them. But in my case, it was quite the opposite. And then it was also just opportunities. Now, wouldn't be right away. Obviously, I had to work hard and prove myself. But I remember with the Ontario trial in Oshawa, as I was, you know, Michael was representing one of the brothers, Alan was representing the other. I was the junior on the case, and there was an opportunity for me to do one of the cross-examinations in relation to the expert. And, you know, I went with Michael to meet with the expert, sent him draft crosses. I was sending Alan drafts along the way, but, you know, in a very public case, I was again given an opportunity that I guess depends on your mentor. We don't always see that. And then that positive, fortunate experience continued when I got to Frank's office. When I got to Frank's office, we would be on cases where there would be, you know, let's say 6 lawyers in the room, all the senior partners for different accused or different parties, and you would never see the junior. But Frank always had me there. Not only that, you know, I would send him messages or privately send him emails about a certain fact, and instead of just saying that and presenting it as his own, he would say, oh, Laura's just messaged me. She has a really good point to make. And Frank is always, for these kind of cases, speaking very highly of me to the clients. You know, most recently, we have a client who is dealing with very serious charges. He's very prominent. The stakes are very high. He's retained and has the resources to hire Frank. And during the bail process, Frank sent me in. Well, I said to Frank, I think you're going to have to convince the client of this, because he's quite particular. I think the first time I met him, even though Frank had said, my associate lawyer will be meeting with you, I was asked if I was the assistant. So Frank said, I'll deal with that. He made a call. Then I did the bail hearing, did a good job. And now, as we're working through this case, the client who, you know, initially was thinking of me as the assistant is now, you know, has confidence in me, trusts me. And now it's going to be a fun learning experience as I learned from Frank and work with him on this interesting case without having to deal with a client that could in other scenarios be quite difficult. I find that particularly, I'm sure it does change, I can only speak to my experience, but when you have clients who have the resources to retain someone like Alan or Frank, the initial process as the junior lawyer, and I'm sure that being a female has a large part of that, can often be a little bit difficult in the beginning because they really want it only to be the senior. And so you can take two approaches to that. You could, as the senior, really just only be the face for the client, report to the client, do everything yourself, but then just have your memos from the junior associate, right? And fortunately for me, my mentors have never taken that approach. They've always, from the outset, instilled confidence in the client with me so that I can then get all of the learning experiences, particularly on those cases where you're a junior lawyer, and the level of experience you get very much depends on whether you're behind the scenes just writing memos or if you're actually in court getting the opportunity to do some of the crosses, to do the bails. So that was a very long answer.
No, it's fine. I just wanted to ask you, just out of curiosity, about the because you did mention about the 11B book that you co-authored with Alan and Michael, and that they did ask you then to for your name to be recognized as co-author with them. But before they did that, did you ever think of asking them? Like, did it ever occur to you? Like, did you ever think to yourself, my name should be there as well? And would you have asked?
I wouldn't have asked. Now that doesn't, that might be my own character flaw. I would not have asked. For me, my thinking was, so Michael was actually trained by Alan as well. Alan's reasoning that he explained to me for why he annotated the criminal code and does all these books, it's not for, he never did it for the publicity or the name recognition. What he did was he wanted to become an expert in these areas of the law, and taking on these tasks would allow you to become the expert. So my thinking at the time was, here's a good opportunity to try to learn everything I can about 11B, to work with Michael and Alan, right? You know, going through the substantive editing process through track changes, I learn a lot from. So I wouldn't have asked, but that doesn't mean that that's actually the lesson that I would want. It's just not, it's just not my personality. And I think that I'm, whether the word is self-conscious or for whatever reason that I don't ask those things. I've just been fortunate enough to have good mentors that that didn't impact me. But I would encourage people to be proactive. I would encourage people to not follow that thinking.
Right. And in fairness, maybe it's also because that was at a time where you were still a newer lawyer, but now let's say this opportunity happens again. Would you ask now?
Well, yeah, so that's very different too, right? If you're right. Now I'm a 2017 call. Now if Frank came into my office and said, I want to write a book on topic X, I would just say to him, okay, we should do this together and we'll be co-authors.
Yeah. Like at least now you feel like you have the confidence to say that, you know, like.
And I should say though, the 11B book was, I alluded to it a bit, but it truly was, the task that was given to me was prepare an index, prepare what you think an 11B chapter book should look like. And then, this is again why people think perhaps, at least in my first 5 years, I definitely worked too much. But what I would do is I would come home at about 8 p.m. and I would just plug away and try try to tackle one chapter. And then I didn't really also, I was insecure or unsure about what I was taking on, but I wasn't really emailing Michael and Alan to say, hey, I'm going to take a stab at trying to write a book. I was just saying, okay, you're going to get the index then around this time. And then as I would complete chapters, I would say, hey, do you want to look at this? So it also, there wasn't really an opportunity for them to say, oh, this is what you're doing, so let's discuss it. It really wasn't until the end of the process that it became quite apparent to them what I had decided to do on my own.
Yeah. Okay. Now, Laura, when you were, you did mention also that that in some cases, and it wasn't your experience, I mean, you were very fortunate that the lawyers and mentors that you've had were giving you, they were very happy to let you shine and, you know, like really put the spotlight on you. But as we know, that's not always the case. I mean, there are a lot of female lawyers who work really hard and they never get really noticed. They're just the associate in the firm and they don't get the recognition that they deserve. So let's just talk a bit more about that, because not everyone has the opportunity to be given these, you know, chances where they can show and where they can be seen and recognized for their work. So let's talk about that. And what advice would you give to female lawyers who are in this situation?
So my advice would be, particularly, it's going to be CLA oriented.
Okay.
My advice
Although this is for WiCCD, let's just be clear. This is an interview for WiCCD, but we can, yeah.
Yes, sorry. It's just because I'm thinking about the For the Defense magazine in particular, and various in-person socials or CPDs. And I do know that WiCCD has their first in-person bail program coming
September
up.
12th, yes.
So that is a perfect example of something that I would be doing. In other words, I would be building my own personal brand outside of the firm, if that was the scenario that I found myself in. And I would be doing things like, so I just recently finished a case on a particularly interesting legal issue that I spent a lot of time on. That wouldn't take me very long to turn into an article.
Yeah.
So then I would submit it to the CLA For the Defense magazine, because I think like 800 people get that. And then your photo is there, your name is there. I am very social, so I actually like these things as well. So I should add that caveat. I don't think people should do the things that they don't find joy in doing. It's a very busy profession, and I think it's important that you're finding and doing things that give you joy and happiness. So I say that with the caveat, but the in-person events are where you meet people. They're where you build your reputation and you start getting seen, even if the firm itself is not building you up. The second thing I would recommend is reaching out to another female member of the bar that you respect and know will keep it in confidence, and ask them about the advice that they would give, having regard to the particular dynamics of that firm. Is the reason that you're not getting billed because the firm is just, maybe it's a very big firm. There's 10 associates and 1 senior, and that senior just doesn't have the time to take the steps that would help build the person. Because in that scenario, what I'd be doing is creating opportunities and then going to the senior lawyer and presenting them with ideas and things that help build your profile, help build your reputation. But perhaps the reason it's not happening is simply because the person's too busy, as opposed to a situation where the person is just intentionally not providing those opportunities. both exist, but if you're in a scenario where you're trying to figure out how to build your career, if you seek advice from another person that you respect, you can try to figure out exactly where the issue lies and what the steps are to address it. Because the step might be consider other firms, right?
Mhm.
I mean, we're
Okay.
not
Yeah.
married to our employers. We're not obligated to stay forever. And if
True.
you're not getting the opportunities that you deserve, and you've taken steps to do everything you can to get those opportunities, but you're still not getting them, then in private with your confidant, you're thinking about other firms that you should be reaching out to, or perhaps you're thinking about going on your own.
Yeah.
Because I don't think that you should be somewhere where if the person's intentionally keeping you a secret, or that's
Or
just
just
not.
doesn't have time to promote you and help you. Like you should, at some point, like you need to have your own, you know, recognition.
Yeah, I mean, it's a stressful profession. It's a long profession. I think it is really important to be surrounded by people that support you
Yeah.
and want you to succeed, that give you the tools to succeed. And it's a quid pro quo. You're obviously working hard for them and you're doing everything you can to add value to that firm. But we're not in, our profession is different than the typical employee-employer relationship. At all times, a lawyer, number one, could just open up their own firm, right? So we have no that, which is just a bit different than your typical 9-to-5 idea that you have of an employer-employee relationship. But the other thing is that you're a professional and you have duties to your clients, you have duties to the court, and you need mentorship, right? I need mentorship today. I need a lot of mentorship. And if you're not getting that, then I think you're looking at other options, whether that's getting mentorship outside of the firm or just
Leaving. Yeah. Or leaving the firm. Okay, so Laura, what we just talked about is really about this dynamic between female lawyers and the male employer. But I mean, we also, as female lawyers, it's not just the male employer who could be, like a challenge sometimes. It's also dealing with the other males in the profession, crowns, or the judges. So how, just let's talk about that.
Sure. So, I mean, so I have two examples, and they will be on both ends of the spectrum. With the high level message that I think when we get support from our male colleagues, that instills confidence in us, which allows us to advocate and represent the profession to the level that it should be. I inherently I'm less insecure now, but I just inherently have always been someone that's been insecure about my abilities, whether it started from a very young age. And as a result of that, how I advocate certainly depends on how my level of self-confidence. So I know, for example, last summer, this was not an example we talked about, but it's coming to my head now. So last summer, I was in a trial with the partner at our firm, Bill Thompson. Our client was a very smart, not tending to identify. So a very particular person in a very high stakes litigation. He had high standards. Bill had me deal with some of the witnesses. And just on that day, I was just very nervous that day. It was not going very gracefully. It wasn't bad. You could hear it in my voice, right? I'm starting to shake. It just was not my A+ performance I would have liked to do. And then afterwards, Bill and I kind of debriefed. He explained what went well, where he thought the struggles were coming from, and identified that, it was his first time in court with me too. And he said that I seemed to be quite nervous. So the firm had decided to send me to a 2-week trial advocacy program in the United States, where for 2 weeks, all I did was get on my feet and litigate. And at the end of that, I came back and I had a prelim and things went much better. I was exponentially better because the firm had identified that my issue was confidence. And so how can we get her to be more comfortable on her feet? Let's go invest and spend the resources to get her into the program. Now I appreciate that not everyone.
Yeah, that was what I was going to ask. Like, not everyone has that opportunity. So
but there are, we have in-person things like the bail program that WiCCD's doing. I think that, one of the things we can do here is start working on creating those kind of programs in Ontario that are more affordable, more accessible. And so that's just an example of, instead of giving me comments that would have probably lowered my confidence.
Exactly, because that's a problem, right? Like, I mean,
right.
no, but that's a good point that you're bringing up, because I do want us to talk about this, because this is, unfortunately, we see this happen sometimes, that there are some unnecessary comments that are made in court. Sometimes crowns, you don't have the nicest crowns, although there are some really very nice crowns and they do help. They do help the defense sometimes, but there are also some who are not. And when they see that you're in trouble, they kind of enjoy seeing you sinking and they just want to help you get into more trouble. So, and it is a very sad and difficult situation when you're the lawyer who has to go through that. And it's because, especially for defense, I think it's more problematic for a defense lawyer because you have a client who's in court, who's watching, and it's really problematic because it does have an impact on the relationship between the lawyer and the client. So, I mean, for these situations when, you're in court and you're not dealing with the nicest people and they're making these comments, how, we've all had situations where it was a bit difficult, but what would you say, Laura, for these moments?
So I had a case a few years ago where it was a project case. There was a number of counsel involved, but as the project developed or ran through the system, clients are dropping off. So that team of lawyers that we once had is dwindling. And so we had been splitting work. Megan Savard was going to be arguing a motion, I believe, on, I think it was, let's say, a Thursday. And I had been the one working with her and prepping it, but she was the one that was going to be litigating this particular aspect of a pretty complex Garofoli motion. And less than 24 hours beforehand, where we also have competing 11B issues. So Megan's client's charge gets stayed because of excellent work and an issue that she had identified. And I am now going to be arguing this complicated motion where I that was not the plan. It didn't mean that I was scared, but I was obviously quite nervous. And there was still a number of other counsel there that I highly respected. I'm cognizant of the fact that that I want to do a good job, that I want to present well. And it was actually in an area of the law that I've written on. I was very confident about this issue going into the motion. I was just a little shaky in my in-person advocacy.
And overwhelmed, right? Like sometimes it's scary to do these types of cases.
Yeah, and it was interesting because what happened was, in reply, the Crown attorney, who's male, was saying things like law school 101. Well, if Ms. Metcalfe went to law school, she would know X. And in the moment, I think
that was in the reply, in writing?
response submissions. if that happened today, I would know to not get shaken. I would know that, you know, this law, it's a complicated issue where the courts are dividing. You've read all the cases, you've distilled it, you've written submissions. You know that what you are saying is not a failure to appreciate basic legal principles from law school. But I did not have that confidence then. I was quite shaken. It was, thankfully, he was long-winded in his submissions, to say the least. And so my reply actually went over a day. And so in the interim, a female Crown on the team had given me a call to say some positive things about me. And the other defense lawyers, including Marco Shara, like they had gotten on the phone with me and really just reiterated that substantively that was ridiculous. You know, but I think what would have been nice, is if the judge had have, when, you know, it wasn't just one or two comments, if the judge had said, you know, these submissions aren't helpful.
Well, that's the thing. Did the judge say anything?
Response substantively. So no, he didn't say anything. He didn't, and I don't know whether I would say he had to by any means. I think it would have been nice if he had have. You know, on the flip side, earlier this summer, I was in Perth for a complicated sex assault case. There's reasonable steps, there's multiple complainants, there's multiple legal issues. There was about 10 witnesses. My client was there, his parents were there. It's my, you know, it's my case. I was quite nervous. I was very prepared as things went through. The processes were going well. And on, you know, I think on the last day, the last witness, I was a smaller witness. I'm going to kind of regret saying this to everyone because I probably shouldn't disclose this error, but I will. I had missed something in the disclosure. I knew everything else back and forward, and I had missed this one piece. And so the Crown goes to cross-examine and says, do you recall X? And as soon as he says that, I realize I don't have X. So I don't know whether this was the right decision or not. I just stood up. The judge, so this was a male Crown and a male judge. He stood up, the judge kind of looked at my face and said, I'll give a 5-minute recess. We went back to the disclosure. I saw what happened. I prepared up to the prelim and it came afterwards and I didn't make an update. But in any event, I spoke to the Crown. I was, you know, my client's there in a very high stakes, difficult case. I said, I'm going to bring an application to reopen my cross-examination. Because sorry, he was in re-examination, right? He's re-examining on this point. And the Crown could have said, no, you got this disclosure on date X. I'm in re-examination and I'm going to be opposing. And then I would have had to, I would have still brought the motion and I would have had to say a lot more things on the record that I wouldn't have liked to say on the record. Instead, the Crown was quite reasonable and fair with me. He consented. So when the judge came back, I notified him. But very briefly, like the judge was also, you could kind of see signaling with me, we don't need to put too much on the record here, and just granted the application. I went back to my cross, clarified that one point, and then we moved on. Now the next day is closing submission. So I'm a little bit, the confidence that I built all week has now taken a little bit of a dive. And the Crown called me that night to tell me that my cross-examinations of the complainant were excellent. He thought that I was an excellent litigator, that I'd done a really good job on this case. And that meant a lot. Then I came in for my closing submissions with my confidence back up. He did get acquitted. And I just think that, you know, when you contrast those two experiences, it's a professional bar where we should all have one goal in mind, which is, you know, a fair justice system. And when our colleagues, whether they're male or female, but particularly when there's that male-female dynamic, when they are encouraging, that has a positive impact on the accused lawyer's ability to advocate the case the way that it should be done in order for our system to be functioning and operate in the way that we want it to operate. So.
No, and that is a really good point here because it does make a difference. And when you are working in an environment that is supportive, and that even if you make a mistake, I mean, there's absolutely no benefit to just criticizing a lawyer and shaming them. Like, yeah, at the end of the day, like you said, like this is here, like we're working in the administration of justice, all of us, like whether it's crowns, defense, or judges, and our goal is ultimately to get to the truth. And so we shouldn't be just like trying to destroy the other or try to put down the other side. I mean, whatever helps the case and makes it a fair process is what matters at the end. And I mean, the good thing here, though, is that you're obviously now a lot more confident and you're not, you know, like if you had some insecurities, I know you're going to say you still have insecurities, but at least now you're much better at knowing how to overcome them, I can say. So Laura, I wanted to thank you so much. That was really very nice that you got to share with us some of your personal experiences. And we always like to hear, I mean, especially, you know, like new lawyers, that's what they want to hear. They want to hear what, you know, more senior counsel have gone through. And it's very nice that you took the time to share with us those experiences. And it's very nice to see you, you know, like how the evolution of how things are going. And you're doing a fabulous job because people know you as Laura Metcalfe. And it's very nice to see that. So I want to thank you for being my guest here today. It was really very nice to chat with you.
Yes, thank you so much for having me. I love this segment that you've done. I know it takes a lot of work. You're obviously also a busy lawyer, so I appreciate it. I'm sure many of your viewers appreciate all the time and effort you put into this program. So thank you so much for having me.
Well, thank you, Laura.